So yes, I'm an entrepreneur myself. I have founded Innovare IP. I started trading in March this year. And today I'm just going to give you flavors to the difference between innovation and invention, and then talk about patenting in the area of software patenting. Let's see how this works. So there's so many types of intellectual property, and I'm glad that the previous speakers have started talking about IP, and patents come to mind, of course. Is there a laser pointer here? No, okay. So, so patents come to mind, so they're right there at the top, but then we have data and database rights, and this is something that everybody in this room uses or creates. We have know-how, we have trademarks and brand names, of course. I've given some examples there, and we have software. And we have copyright for either teaching materials, writings, and so on. We have design rights for the way things work. I see that smartphones are very popular as examples today, so I'm glad that I'm staying in the same area there. And we have reagents and tools. This may be a little bit removed from what you are doing. However, the biotech area is one that combines biology and software. So let's look at these intellectual property rights in a little bit more detail, and it is a crowded slide. By the way, I can share the slides after this, so you can contact the organizers. And there are essentially two types of intellectual property rights, and why have I highlighted a few of them in yellow? Simply because, in my opinion, these are the types of intellectual property rights people in this room should consider using. So we have automatic protection, which is one that, as the name says, arises automatically. You don't need to apply for it. And we have copyright and database rights. And the duration of copyright, for instance, is the life of the author, the life of the creator, plus 70 years after death. We have unregistered design rights. This lasts 14 years from creation or 10 years from first marketing. We have unregistered trademarks, that's the lifetime. And most importantly, we have know-how and trade secrets. And the duration of this right, of course, is indefinite, provided it is kept as a trade secret. And the first speaker was talking about the interplay between keeping something to yourself, so keeping it as a trade secret, or sharing it with the community. And then we have registered protection. So you have to apply for it, which means that you actually have to start to spend money. And we have trademarks. The trademarks last the lifetime of the mark, pretty much, provided it is renewed every 10 years. We have registered designs, of course. They last 25 years, renewed every 5 years. So apart from, you see there's a theme here, apart from having to spend money to register the right, you need to maintain it, because registered rights are monopolies given to the applicant, to the inventor, to the creator by the state. So you have to pay money to maintain them as well. And of course, we've got patents, and they typically last 20 years, and they have to be renewed typically every year. And we have something called utility models, and they're very similar to patents, but they only apply to certain countries. And whilst patents take longer to grant, utility models can be used as a way of protecting products with shorter shelf lives, for instance, and they are cheaper to obtain. So what is innovation? And I would like to read what is on this slide, because innovation, there is a distinction between innovation and invention. So pretty much innovation is an advancement over existing knowledge, and you can either come up with a new idea in the form of a device, product, process, or, importantly, you can use existing knowledge to create new uses for known devices, products, processes, or to improve existing processes. I shall be talking more about processes, because I guess this is what applies to software, so processes. So as you see, you can either come up with something brand new, and you already see that that could potentially be an invention, but equally you can use existing knowledge to find new uses for processes, for applications. And this is what the software or the AI, whatever you want to kind of group this sector, does a lot of. So you prefer to share the knowledge, and then you find new uses for that knowledge, new applications. You are focusing on the functionality. So you're innovating. So innovation is the application of original and more effective solutions, pretty much, to meet new requirements, to solve problems, to explore markets, to create new areas of technology. And the innovation is implemented via an engineering process, via process, solution to a problem of a technical or scientific nature. Technical is very important to remember. It's a buzzword for us just now. So innovation, in other ways, paves the way to inventions, so that the innovation involves the practical implementation of an invention. So having said that, patentable innovation, I will call that an invention. And I have given some legal text here, but I have highlighted the bits that you should take home with you. So the UK legislation at the top and then European legislation at the bottom. So a patent may be granted for an invention if these following conditions are applied. The invention is new, involves an inventive step. It means that it is not obvious to somebody skilled in the particular technical field. It is capable of industrial application, and the grant of the patent is not excluded. Okay? We'll talk about exclusions because this is where software finds its way into the legislation, patent legislation. And one thing that the UK legislation doesn't mention is the fact that you have to have something technical. So there has to be a technical aspect associated with the invention, and this is actually mentioned specifically in the European legislation. So what is it that are not considered as inventions? So discoveries, scientific theories, mathematical methods, literary, dramatic, art, they can be protected by copyright, obviously. And another not invention is a method of performing a mental act, playing a game, doing business, or a program for a computer. But these are only excluded to the extent that the patent relates to that thing as such. So the software code itself is not patentable, but as you will see, we try to find a technical effect associated with that software code. So, in other words, activities which are non-inventions would represent purely abstract concepts, but this exclusion is interpreted narrowly, and what pretty much characterizes a non-invention is the lack of technical character. So what is technical in the context of software inventions? Processing physical data parameters or control values of an industrial process, or processing which affects the way a computer operates. So it saves memory, file compression algorithms. It increases speed. It improves the security of a process. It improves the rate of data transfer. Or another thing that's technical is the physical features of an entity, so the memory and the ports. And you already see that if you take the example of saving memory or increasing speed, the software does something to the hardware being the computer. So the hardware functions differently or functions faster as a result of the software code which was written for it. Let's look at computer programs from a different perspective. So every computer program obviously causes technical effects, like the flow of electrical currents. But these are not sufficient to avoid the exclusion, i.e. the exclusion of that's not an invention because it's not technical. So the computer program, in other words, will have to have the potential to provide a further technical effects. And there are some examples here. So the further technical effect, control of a brake in a car, again, is the brake, is the hardware, is the physical thing that is affected by the software. Faster communication between mobile phones, secure data transmission or encryption of data, resource allocation in an operating system. So these are further technical effects, and would write software claims, claims for software patents in a way that these further technical effects are emphasized. So no further technical effect, aesthetical effects of music or video, new rules for an auction scheme, selling and booking sailing, cruise packages, calculation of pension contributions. And these are established cases which have been rejected over the past 20 plus years. So how do you manage innovation? Ideally, it should be committed to written documents. And I know that we are slowly moving to electronic means of storing information, so this is absolutely fine. And you should use the principle of audited lab books. So although you are writing something, you come up with an idea, you write it somewhere, you should actually ask somebody to testify that, yes, I've seen it, it was created at this particular date, and so on. And it should be dated and traceable, complete and transferable. And the scenario that I always like to mention is that of the innovator being run over by a bus. Would that innovation, go away with them, disappear with them? Hopefully not, because by that time it would have been stored somewhere so that it can be transferred. And in the simplest, most basic way, the way the innovation should be managed is by keeping track of it. And once you do that, there should always be a continuous decision-making process. So is it innovation or is it invention? If you want to keep that innovation as know-how, trade secret, or confidential information, then just keep it to yourself and in a way create some boundaries or prevent others to have access to it, or decide who you want to share it with by means of non-disclosure agreements, for instance. However, if there is enough commercial value and you decide that the innovation should be elevated to the state of invention, then you have to think of all of these criteria that the invention has to pass. Has to be novel, has to be inventive, and shouldn't be excluded. There are various scenarios for obtaining a UK patent. So this is a direct UK filing. So we start with filing a patent in the UK. We call that priority. Then the clock for that patent starts to run. Remember, patents last 20 years. So as soon as we file the UK patent application, the 20-year clock has started. And you can obtain a UK patent in as little as 9 months from filing. So the patent is filed. I've mentioned the US. I'm aware that patents are perceived to be filed or to have an easier time. Software patents are perceived to have an easier time in the US. Hence, many software companies, even those based in the UK, would prefer to file the priority application in the US first. US and a few other countries, not that many around the world actually, operate a 12-month grace period, meaning that even though the invention has been disclosed by the inventor or inventor's company, the inventor has 12 months from disclosure to file a patent application in the United States. This grace period does not exist in the UK, it does not exist in Europe. So if a disclosure has occurred, a patent can pretty much only be obtained in the US and a few other countries like Japan, for instance, which apply the grace period. The patent will be searched and examined, will be published, and then will be granted. And as I mentioned, you have to pay an annual renewal fee. I've given a few examples there. Year 5, the annual renewal fee is £70. Year 20, the annual renewal fee is £610. So for UK patents, these fees are not very high. And why would you want to have a patent? Because you can enforce it against potential infringers. You can enforce the patent after grant. However, damages for losses due to infringing sales can be backdated to the publication date. You may have heard of Patent Box, which is a way for commercial organization of reducing their corporation tax. So UK patents can qualify for a Patent Box claim, and although the Patent Box claim can be made after grant, you can include profits for sales occurred whilst the patent was pending. And you can expedite the grant. There is something called Patent Prosecution Highway, so PPH. And this is a list of countries which share the search results, examination results amongst themselves. And I have highlighted US, UK, Germany, Korea, and Japan. So pretty much, if you had filed a patent application in the UK, and it is likely to grant, you can quickly take that patent application in the US via the patent prosecution highway. And the likelihood of that patent being granted in the US quickly is very high. And with that in mind, I'm going to leave you here, whereby my other legal professional in the room is going to start to talk about ways of using the IP, and licensing is one of them, and there are a few people in the room here who will also talk about making use of innovation by means of licensing it in. And that's me, and these are my details.
Thanks, Claudia. Thanks very much.